Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Tuesday, April 7th, 2026 at 9:10 in the morning. So we're going to begin our week with continuing discussions on S-173. Again, an act relating to vocational rehabilitation. We have Kelly Massicon with us. Good morning, Kelly. Thanks for joining us.
Good morning. Can you hear me okay?
Yes.
Yes.
Perfect. Thank you.
I think we want to continue chatting with you and I think maybe some information about pre-screenings you have and continue those talks. So thanks for joining us.
Thank you. And thanks to everybody in the committee for continuing to be open to hearing this discussion. Again, my name is Kelly Massicott. I'm an attorney who's been representing injured workers for 20 years here in Vermont, and I'm here on behalf of the Vermont Association for Justice. As you know, I strongly support this bill. I urge you to pass it in all parts. Certainly, there could be a little bit of tweaking on what the committee is perhaps charged with, so it's about more open-ended. So there could be some more consideration of improvements to the voc rehab system. But I do believe very strongly, as I know my colleagues, frankly, on both sides of these claims, that the screening process that is now in the law should absolutely be eliminated. And I do have some information to share about that, which I think will highlight for you why it is rather urgent and why we shouldn't wait for the committee study to review the screening process. So just to review quickly for you folks, recall that in workers' comp, again, there's these 4 benefits that an injured worker may be entitled to. Medical benefits, number 1. Wage replacement benefits if their work injury takes them out of work while they're recovering, or they're working less and earning less due to the work injury. Those wage replacement benefits are called temporary disability benefits. Then there's another benefit that someone might be entitled to called permanent impairment benefits. That's a limited monetary benefit after those wage replacement benefits end. And then finally, there's this vocational rehabilitation or voc rehab or VR that we call it for short. Under the rules, VR Rule 51.3 defines vocational rehabilitation, and it defines it as the delivery and coordination of services designed to achieve the goal of returning the injured employee to suitable employment as quickly as possible. So that's very important for us to focus on, which is it's the goal of returning the injured employee to suitable employment as quickly as possible. And we'd all like for the injured employee to go back to the job they were doing at the time of the injury. And in the vast majority of cases, that is what happens, actually. But for a small number of folks, that isn't what happens initially, eventually either. And so VR is something that needs to be considered. And if an injured worker may be entitled to it, they need to be reviewed for that benefit and their eligibility for it promptly and efficiently. So in that definition or in that goal of vocational rehabilitation is this, this term suitable employment. And I just want to highlight that suitable employment has a particular legal definition. Suitable employment has a few different pieces to it. It's got to pay close. It's got to pay as close as possible to the pre-injury wage. We've talked about this concept of average weekly wage. We look at the 26 weeks prior to the work injury. We come up with an average. That is that average weekly wage affects 3 of the 4 benefits I just reviewed. It affects all of the benefits except for medical benefits. And as I explained to the committee last time I testified, when we're looking to replace an injured worker's wage, we are only concerned about what they were earning in that 26 weeks prior to the injury. And I gave you folks the example of me as an attorney. If I decided to stop practicing for a period and I went to work on a farm and I got injured on the farm, and perhaps I could never practice law again as a result of a work injury on the farm, workers' comp and vocational rehabilitation would only be focused on that wage I was earning in that farm job. So we have to understand there's a lot of trade-offs in the workers' comp system on both sides, but that is one of the big trade-offs for injured workers is we are with that wage frozen in time, so to speak, of what they were earning prior to the injury, even if that person's earning capacity is much greater, but they just didn't happen to be earning those wages or that kind of income prior to the injury. So that idea of suitable employment, again, suitable employment is a very important notion in voc rehab. It has to do with that wage. It also has to do with the job. If you were injured doing a full-time job, that's the kind of job that you should be returning to at that wage. Again, hopefully for the employer, but if not possible, and you're eventually entitled to voc rehab, that is what the injured worker and their counselor will be working towards, is a full-time job at that same kind of weekly wage. Likewise, the commuting distance and that kind of thing also has to be similar. So if somebody regularly commuted an hour for their job and they can still do so despite their work injury, then that's a reasonable commuting distance that would be looked at in terms of trying to get them back to suitable employment. So these factors, the wage, whether it was full-time, part-time, temporary or not, the commuting distance, these are factors that we look at both on the eligibility side and on, if they are found eligible, on creating a plan for getting them back to work. Because again, that's what the injured worker is entitled to. If the work injury did not allow them to go back to work for the employer, then we're trying to get them back to suitable employment, which includes those factors, the right wage, it's a similar commuting or less. And obviously an injured worker could say, hey, I'm willing to drive further from a commuting distance. There's a great job or there's a great opportunity. They're allowed to, or they can say, I'm willing to earn less. But this is what the law sets out that they are entitled to. So again, the notion of suitable employment has several facets, and it's an important definition that we need to keep in mind as we're discussing this screening process. So as you know, about 20 years ago, the screening process was implemented. It was an attempt to find a cost-effective and efficient way to try to identify injured workers who may be entitled to these voc rehab benefits. The law also spoke about trying to avoid any conflict of interest, and it specifically mandated that this first step, this screening step, would be done by folks who are not the normal voc rehab counselors certified by the Department of Labor, who normally, once somebody's found entitled, do the work, creating a return to work planning, helping that person get back to work, whether it be through classes or training or what have you. So 20 years ago, it was specifically decided to have this screening taken outside of the comp process. And currently, as we've talked about, it's state of Vermont voc rehab folks who do this screening. And last time I testified, there were some questions about who pays for it, how much does it cost? And I did find some answers to that. It looks like it's currently anyways $160 charged for each screening done. And it is paid directly to the state. I have a bill, it's redacted. I didn't send it today, but I'm happy to forward it to the committee if you'd like to see it. But it costs $160 that the workers' comp carrier pays to the state of Vermont when the state of Vermont voc rehab folks do this screening in a claim. So as we've talked about, the trigger is supposed to be at 90 days. It's a form, it's a memorandum form 25M that a carrier files with the Department of Labor that shows an injured worker has been out 90 days. that is supposed to trigger the screening within the state of Vermont between Department of Labor and Dale or whoever from the state is doing the VR. And as part of that process, I'm sorry. Oh, I thought.
Go ahead. You go.
I thought I heard something. Sorry. As part of that process, the workers' comp carrier uploads medical records into a portal, secure portal, so the Dale or the state VR folks who are doing the screening have access to the medical records. And then they also reach out to the employer and to the claimant as part of the screening process. I forwarded to you folks examples. This is just one case, and I've redacted all the identifying information about the claim. This is not my claim, by the way. It's really, I feel bad. There's a testimony on the Senate side, February 5th. Karina Dunnigan, who's a VR counselor, a private VR counselor who works with injured workers. She's the one who does this work once when somebody's found eligible and helps them get back to work. She testified before the Senate committee. And I urge you, if you have a chance or are interested, to watch her testimony, but I'm going to summarize and explain what she spoke about in front of the Senate committee. And I apologize, she's unfortunately hasn't been able to appear before you due to scheduling conflicts. But her testimony is very important for you to understand because it does illustrate the real problems with screening. So just to give you the background, this claim, again, not my claim, but the gentleman who was injured we'll call him Sam. He suffered a right ankle fracture at work. He was a stove installer, which requires very heavy physical work, very physical demanding work. He has to carry more than 100 pounds at times in his job. And he has to climb ladders as part of that and still carry heavy loads. He was injured April 10th of 2023, and he went out of work. And what went right in this case is at 90 days, it was referred for screening. So that is absolutely something that went right. That often does not happen. I have other examples where the screening was delayed. So the first step was correct. It was referred for screening after 90 days, and the screening was completed at the end of July. On the first page that I forwarded to the committee is a screening form that this is what the screening folks use. And it's dated July 31st of 2023. So again, this was a screening that was done very promptly. And what I just want to point out generally is there's a medical summary. There's a note about what the employer contact said. There's a note about what the claimant said. And then there's 3 questions at the bottom. And these 3 questions dictate how they're answered, dictate whether this screening goes on to the next step or not. The next step is to go to a VR counselor who is trained in workers' comp, like Ms. Dunnigan, the person who testified on the Senate side. That's the next step, is to push this beyond this screening process to a VR counselor who is certified by the Department of Labor to work with injured workers and have them do an actual entitlement assessment, an eligibility assessment. So again, this is kind of a first step. The answers to those 3 questions where it says screening recommendations. And what it's supposed to be is if there's 2 or more of the responses are answered in the negative, it is supposed to go on to the private VR counselors for them to make a determination. Again, in this case, the gentleman had just been out of work a little over 3 months. Unfortunately, with regards to medical records, there's only records from a month or so after the injury. So right there, the screener is a little bit at a disadvantage because they're reviewing this claim in July, late July, and they don't have records for the last 2 months. And the gentleman's been out of work 3 months. So they have records for the first 5-6 weeks only. They don't have more recent records. But they talk to the employer and they talk to the injured worker. And basically, the employer says, well, you know, the guy's in a walking boot, and if he comes, we'd like him to come back as soon as possible. We'll try to keep him on the ground, right? Because they know they need ladders and all of this. So that's the employer's comment. And the injured worker is saying, I want to get back to work. These are my follow-up appointments. So hopefully you guys have this screening form that I forward. I'm on my iPad. I can definitely try to share it if folks don't have this in front of them. Would it make sense for me to?
We have it, Kelly.
Thank you so much. That makes my life easier. I'm kind of on the road and not in my normal surroundings right now. So under the screening recommendations, has employee been medically released to work? No, that is correct. 2, does evidence indicate that employee will eventually be able to return to his or her job? Think about the way that's phrased. Does evidence indicate that employee will eventually be able to return to his or her job? Look at how the screener answered this. No evidence to the contrary, they said. So they answered yes. I don't think that's the proper way this should have been answered. If there's no evidence showing that this person would likely be able to return to their job, if anything, it's unknown. But this person answered yes. The way the question was phrased, I think you need to have explicit evidence indicating it's likely they're going to go back to this job for it to be answered yes. So I believe that was answered improperly. And then the last question, does employer have, here we go, suitable work, right? Suitable work available for the employee. I don't think these state VR folks have been properly trained or educated on what suitable employment, suitable work means, nor do I think they can do it in this quickie screening. It's just too nuanced, and there's just too much background information that needs to be collected to really understand the suitable employment piece of it. This person, the screener, said yes, that there was suitable work available. Again, I'm not sure that that's correct when the employer is saying, we'll try to keep them on the ground. This is somebody with a broken ankle who has always done physical work, who struggled in school, who did get their GED, but has always worked on their feet. And he's 3 months out from the work injury. And both the employer and employee want him to go back, but there's no indication that he is going to necessarily have a successful recovery from this, allowing him to get back on his feet doing this kind of heavy job. As an aside, and Ms. Dunnigan mentioned this in her testimony, and I know this too after years of doing Social Security disability work and workers' comp, folks who have a foot or ankle injury, they are very hard to slow and hard to recover from, especially with weight bearing. So somebody like this gentleman who worked on his feet all the time and did very heavy work of lifting over 100 pounds, I know right off, there's a good chance he might not be able to get back to this type of work. I think he's also in his mid to late 40s. That's another piece. There's a good chance that he might not be able to get back to this type of work. So this screener found 2 yeses and a no, and according to the form, they're not going on to the next step of meeting with a VR counselor who is actually certified by the Department of Labor and Workers' Comp, who's familiar with workers' comp. They're not being forwarded to that next step. They're actually being recommended to be following up for another screening in 90 days. So that's what happened there. Unfortunately, according to the timeline, that didn't happen in 90 days. It happened, instead of 3 months, it happened 5 months later. So it should have happened in October. It actually happened in December when the next screening happens. So that's page 2 of the attachment that I sent you folks, and we don't have to read through all of this certainly, but what I can tell you is at this time, he's still having difficulty. He's not healing. Well, there's problems with the ankle brace. He has tried to do, he's hoping to do light duty, but he's had issues. They're saying no surgery, but again, he's still having difficulty. And when the screener, by the way, when it gets sent back for another screening, it does not go to the same screener. So the person looking at this a second time has no familiarity with Sam's claim. He doesn't remember, or he or she was not the screener who looked at this the first time. It's somebody looking at it with fresh eyes. And so again, it's 5 months later, and this screener is now looking at these questions. By this time, Sam has tried to return to work, but he had difficulty, and after 2 days was taken out. He's eager to get back to work, but it's not going well. So under the screening questions, has employee been medically released to return to work? Yes, the answer is yes. And the screener notes, well, he returned for 2 days, but now something else seems to have come up with the injury. So he's medically released, but it didn't go well, which lends towards maybe this person should be looked at for possible vocational rehabilitation consideration. But the screener answered yes, which doesn't support moving in that direction, right? We need no's to move in that direction. Does evidence indicate the employee will eventually be able to return to his or her job? Yes. Again, I think that's unclear at best. And then does employer have suitable work available? And they are saying yes. The screener notes the employer is frustrated that he's been out of work. And I understand that. The employee is frustrated too. So this again was not sent on. There's 3 yeses this time. So follow-up screening in another 90 days. That's December 11th. The next screening is then done March 1st, I believe. Sorry, I'll grab my right. Sorry, 1 second. I got my pages mixed up. So finally, on this one, and this is the last 2 pages of that attachment, we have yet a third different screener from the state looking at it this time. And you can see from the medical summary that there's a lot going on with this gentleman now medically. I won't go through everything, but things are not going well. The employer is also saying, like, I'm not a doctor, but like, I can't have him come back unless he's 100%. There are some employers in some places where they're going to be willing to take somebody back. They can find another job for them, even if they don't come back at 100%. But this employer is telling the screener, this guy's got to be 100% or we're not taking him back. That's under the employer section. The claimant is telling the screener, I don't have a lawyer. My recovery has been a slow, miserable process. My balance is still bad. I have little rotation on the left and right of my ankle. I'm getting a second opinion. And it sounds like I need surgery. My tendons are damaged. I'm not healing. He's clearly in the thick of additional medical treatment. So this third screener is looking at it and they're answering those. It all comes down, folks, to these 3 screening questions. That's what the screening is, and that's what allows somebody to move on to the next step. Has employee been medically released to return to work? No. Does evidence indicate that employee will eventually be able to return to his or her job? Unknown. Again, I think the answer is no, because there's no doctor saying, I believe he will likely be able to return to this work. We have cases where that's said all the time. The doctor says, I believe this surgery, after this surgery, they'll be able to return to a medium duty capacity. And then the proof is in the pudding. Sometimes they don't, they aren't capable. And then we look at pushing VR later on if the person didn't have as good of a recovery as the doctor anticipated. But in this case, there's no medical provider saying, oh, I think they're going to get back to this very heavy work doing stove installation. So if there's an unknown to question 2, I think it should be a no. And then finally, number 3, does employer have suitable work available? And the answer is no. So on this third screening, we have 2 no's. And again, it says right on the form, if 2 or more of the above responses are answered in the negative, the injured worker shall receive an entitlement assessment. I have no idea what happened in this claim, but the next line, referral for vocational rehabilitation entitlement assessment? No. the person filling out this form is not even following the directions on the form itself. And so this is sent back for another screening in 90 days. This gentleman, so by this time, he has been out of work 11 months, almost 11 months. Folks like myself or people who do voc rehab for workers' comp certainly recognize this is the type of gentleman who may very well need, is very likely to be entitled to VR because of his education level, his work history, and this particular injury affecting his foot, where he's always done standing work and very heavy at that. So it's 11 months out and he still has not gotten past this screening phase. This is an example where screening was actually referred timely. And I've got to tell you that that is oftentimes a common complaint is that the screening is not done timely. I checked with a couple of colleagues just to ask them, hey, what do you see with screening? And I had a colleague mention to me, and it often happens when we start representing somebody, gentleman out of work, mid-December of 2023, the attorney gets hired almost 2 years later in November of 25, had never been sent to screening. Somebody had been out of work almost 2 years and it had never been sent to screening. In another case, a gentleman had been out of work and it was 7 months before. And again, it's only because that person hired an attorney that the attorney recognized this is not working. We need to get the screening done. Even when we know the screening should have been done and it's not done, and we recognize that, and we go to the Department of Labor and say to the workers' comp carrier, please refer this for screening, it's a slow process. It can take weeks, if not months sometimes, for that to get done. So Ms. Dunnigan was finally, back to Sam, the example I was just explaining in those forms I was just going over with you guys. Ms. Dunnigan was finally, I think the gentleman hired an attorney because he was so eager to get back to work, and he was frustrated because he recognized that treatment was ongoing and he was going to get to a point where the money was running out and he didn't know what his next job was going to be. And he did hire an attorney. The attorney recognized how broken the screening process was, especially in this example, and pushed very hard at the Department of Labor with Defense Counsel to try to get a direct referral to a VR counselor. And it was Ms. Dunnigan who testified. But by that time, I don't think that he hired the attorney until September of 24, and it wasn't until November of 2024 that that VR counselor was then allowed to be on the file. It took, I think, 6 weeks or more for the attorney representing him to show the Department of Labor, show the defense attorney what I just explained to you folks, and finally get beyond that screening step. So once the VR counselor was on the file, she found him entitled in 6 days. It was done very quickly and they started working together. But again, this person was out of work over almost 18 months, I believe, when he finally was working with somebody who understood the workers' comp system and could start working with him to come up with a plan for a different type of position. The unfortunate thing, and Ms. Dunnigan talked about it in her testimony, was by that time, he had reached a medical endpoint, which means his wage replacement benefits had ended, and the money's running out. So he's urging his treating doctor, please release me to do work on my feet. There's no other job I can do. He may be entitled to the training and he's working with his voc rehab counselor. He's got to pay his bills now. By the time Ms. Dunnigan started working with him, he was living in a motel. He had lost his housing. Because again, comp does not pay people 100% of what they were earning. And there's other ways that folks are underwater. And he had to beg his doctor to release him to do some work on his feet so that he could get a job, any job, to be earning some money while he's trying to work with Miss Dunnigan to retrain for a less physical job. As I pointed out on the other side, this attempt to save money with screening, folks, we cannot calculate what we are really losing by keeping the screening. I pointed out that this gentleman is probably another work injury just waiting to happen, another claim, because he's on his feet trying to earn any money while at a lower paying job, while he's retraining and trying to get a higher paying job, which he's entitled to, suitable employment, with Miss Dunnigan through the VR process, through the VR benefits. So, and the doctor released him because they felt it necessary. So he's not doing anything he shouldn't be doing in terms of what doctors are advising, but it's not good for him and it's not good for our system. It's not good for comp carriers. We need to have these folks looked at earlier. And as Ms. Dunnigan said in her testimony, the screening process doesn't do a good job at identifying the people who likely need it. It's not being completed timely. It's not being completed at all in some cases. And no one's checking to make sure that it's done correctly. And there's not a good remedy when the system is falling apart. I recognize there's all sorts of improvements we can talk about. I don't believe that there's improvements to be made in this screening process that can help it to save it at this point. To me, it's just not worth it. And I believe that folks on both sides of these cases would agree with me. I know it. Defense attorneys admit it to me. They don't want to say it publicly because they have their clients, the carriers, who have their position publicly. But defense attorneys are frustrated by this too. And somebody like Sam, you can see that this person is losing out incredibly time and wasted resources on behalf of the state to do this screening process. So I don't believe, even with the creation of the committee, which will look at very important issues and ways to improve the system, which I support, I want it to be more cost effective. I want injured workers to get these services and benefits more promptly and more cost effectively. But I don't believe that there's any way we can honestly put this off another year by dropping the screening when there's such erroneous and unfortunate instances like this one with Sam that are happening all the time. And this one we know about because he eventually hired an attorney in my firm. There's countless other examples and many, many more that we don't know about because folks are unrepresented. This is the real problem, is people do not know how to navigate the system. It's hard for me as an attorney to push the screening through, to get to that next step. My colleagues spent almost 2 months after these 3 bad screenings to get it to the next step. Imagine what an injured worker has to try to do to effectively get through this. I just feel that it just is a step that we can drop. And I do want to note that when I'm referring to VR and VR services, I'm both referring to folks who are eventually found entitled and then get benefits like retraining, courses, skills, whatever. But I'm also referring to the entire process, just being how we identify people, how they are, assessed for eligibility, whether that's screening or what have you. I refer to all of that as kind of VR. And so when I say I want to start VR, it doesn't mean that person's entitled. It just means the beginning of the process to identify and properly assess whether they're entitled. Many times that has to wait, or it depends on the medical evidence. And I also want to note that even when somebody is found entitled, if later evidence comes in that shows they had a better recovery than anticipated, the carrier can certainly say, we think the entitlement should be overturned. We don't think we should pay for any benefits here because the evidence now shows they can get back to that job. And so we don't think we should pay for any extra assistance. So there's the system, I think, worked better prior to the screening. And I do think the screening should be dropped immediately. There's just too many instances of injured workers really being negatively affected. And I just don't believe we could wait another year when somebody like Sam, real life Vermonters are facing this system that is not working for them.
Questions for Kelly? Or-
Yeah, thanks. I'm sorry to be late, but I really hear what you're saying about, that an injured worker should get VR services as soon as they can, barring issues around medical treatment, whatever. So I think that's your main point. That's what I was hearing as your main point. And I understand what you mean, what you're saying about the screening, that requirement. But even if you didn't have that screening requirement, such as in the Senate bill, you'd still have this 90-day period, and you're only eligible after 90 days. And then I also heard you're saying that there were eligibility criteria. And is that in rules? Anyway, I'm just wondering if you have any other policy thoughts about how to change policy to get injured workers in both rehab as soon as they can.
The 90 days is currently in the statute as a trigger to try to identify those folks. It says that is the trigger for them to be identified, but the statute also says at any time an injured worker can request to be considered. Practically speaking, unless somebody's represented, they don't know how to go about that or do that. So that's usually the 90 days is what starts the process. And I do think that there are improvements around even that 90-day filter and the communications from the Department of Labor to injured workers about the potential benefit of voc rehab. To be honest, there are cases, it's a balance here because a lot of the people who are going to be eventually entitled to voc rehab are injured seriously enough that with identifying them before 90 days is likely not, I don't want to say it's likely not helpful, but they're usually so seriously injured, they're so focused on medical treatment that it's hard to even start thinking about starting that process and meeting with another person about what's going on. A lot of people who are eventually entitled, the 90 days does seem like I have to say, like a pretty good place marker for trying to identify. But I do think that the committee could brainstorm other ways to potentially identify or allow injured workers the ability to vocalize or to express their interest. Because as I did give examples of folks who could be entitled who would never get triggered by this 90-day out of work thing. So to catch the vast majority of injured workers who might be entitled, I think the 90 days is a good filter or marker, but I do think the committee could brainstorm other ways to potentially identify injured workers who may be entitled other than the 90 days. Yeah.
Thank you.
I hope that answers your question.
Yeah, thank you.
The questions for Kelly? Okay, I think there was, you showed us one example.
Yeah.
And so we don't really know without data coming back whether this is chronic in the pre-screening world or if this is an anomaly. There's things that I can think about how we can move the process along if if there's another pre-screening that's set for another 3 months, and if it doesn't happen during that next 3 months, then it automatically goes to VR. You know, there's other triggers that we can put in there that would force the issue. But I think I'd like to see if we have data from hireability on, and I'd like to know if there is anyone there that that looks at every one of these screenings that happens to make sure that the screeners are doing things properly. It just seems to me that things may be complacent now, and that I think we need to, you know, start thinking about shaking the system up a little bit. And we need somebody that's looking at this. It doesn't seem like there's a place for injured workers to file complaints and for someone to take a look at them, whether it's in the pre-screening or in the VR side of it as well. So, you know, we certainly don't want people going on and come to medical end and still not be able to work. It's not right. So, but for us to try to dig into this as deep as we need to in the next 3 or 4 weeks, is pretty tough. So I think, I know we asked Dirk to bring us, see if he could get us some data, and I think we'll ask, hireability the same question and ask them to see if they can get us data, and we'll have more discussions with them as well. But we want to find out if you know, if this is constantly happening or if this is an anomaly.
May I? Oh, sorry.
Yeah, go ahead.
If I may, I'll tell you it's not an anomaly. I wouldn't be spending so much time with you folks if this was only coming up very rarely. Honestly, it is something that is happening quite frequently. The delay is the bigger problem. The example I showed you was certainly erroneous answers by the screeners, but it also was delay because of those erroneous answers. And then the delay in just getting to the screener, that is very, very, very common. It's definitely not an anomaly, I can promise you. I wouldn't be spending so much time passionately trying to urge you folks to drop the screening.
We certainly want to see the data, right? So one example,
yeah, no,
you know, there were 100, and I'm trying to remember what they said last year, but I think it was 137 cases or something like that. And out of that, 50 were referred to VR and 87 were found not. Yeah. So there should be data in there that somebody should be looking at to see why the vast majority are not going on to VR, and making sure that somebody's looking at what the VR counselors are putting down on paper. May not be right, so they may need to change the system, make sure there's more oversight. But or maybe we need to get rid of it. But at this point, I don't know.
That is the issue, sir, is that there is very little checks on this system at all. Yeah. And so continuing with the screening as is not going to help the issue because of the lack of transparency with the screening process. If we drop the screening process, we go back to where we were 20 years ago, and it's a much more transparent process where at least folks who are represented, I have the ability to push because it's a much more transparent process in that situation. The bill also allows for an injured worker to initiate the VR process. And again, this doesn't mean they're eligible, just to be considered for eligibility and to be looked at. The bill also allows for injured worker to start that if the carrier has not done so. And so that forces it. Right now, if I start with a new client and boy, they've been injured and out of work for 2 years and no screening has been done, should be done at 90 days. I've got to bug the Department of Labor person and say, so-and-so, please get this screening. Why isn't this screening? Can you, and then I got to set a tickler and then I got to follow up. And you would be surprised at how long that can actually take and the process to just get the screening done. And if I'm sitting there on the other side and I know this person's very likely going to be entitled, it's really frustrating to see 30 days, 60 days, 90 days pass when this person could be getting the real help and they're not getting it. And again, they're going to get a counselor assigned to them who's going to make a determination. I'm not the one making the determination. I just am very experienced and know my stuff and recognize this is somebody who's going to be found entitled when they finally get to that point. But it's an independent VR counselor in the system in workers' comp who makes that determination. And so without proper checks right now at the Department of Labor and at hireability on that side of things, it's a very broken system. And we have a very little way of pushing it. And to me, it's much better to drop the screening, go back to where we were, and have the ability for injured workers and their counsel for more transparency to push VR earlier than to not. I mean, I would urge the committee to, if anything, if you're not perhaps inclined to want to get rid of screening altogether, consider getting rid of screening for a year or two while the committee studies it, because I do have a concern, sir, that the data that you ask for is not readily available or the statistics are not well kept. And so if the committee is charged with perhaps reviewing screening as part of it, they could look specifically at the screening forms and do a much closer assessment than relying on some statistics right now that are kind of big picture, and I'm not sure that they would be fully accurate. I would have concerns about the statistics being fully accurate, to be honest. And to me, it would be much better to drop the screening temporarily and allow folks like Sam to be moving faster in the process. A year or two of going back to where it was pre-screening and moving people potentially through the system faster. And if the committee is also charged with looking at screening and seeing, is this salvageable? Is this a way to make this better? Could screening be done differently? Absolutely. But I understand why you want data. I'm a data person, sir, to Chairman Marcotte. I wish there was more accurate, good data that you could rely on. And it's frustrating for me that injured workers kind of feel penalized for the lack of data when unfortunately it's not available, and it's not certainly the injured workers' fault, but they're the ones being harmed because of the lack of data, I guess is how I would put it.
Okay. We have to go
Thank
to
you.
the floor. Thanks, Kelly, for joining us.
Thank you all. I appreciate your time.
No, we'll certainly keep working on it. We'll ask you to come talk to us again.
Thank you. Have a good
Thank
day.
You too. So committee, we're on the floor, caucuses and lunch and back here at 1 to continue discussions on S-173 today. We'll have Sophie. I think I'd like to have Sophie walk us through statute itself, this part of the statute. You changed it.
Yeah.
I think it was less than 20 years ago, but there's a reason why we changed it. So I want to see, I don't remember everything, so I want to see if there's triggers in there that we put in that would force VR.
It'd be awesome, maybe, I can tell it myself, find the DOL rules that talk about this issue, because there was some mention of eligibility criteria, and I don't really see them in the statute.
Yeah, I've been
look at-
looking at the rules a lot.
So the screening, on our page is, she sent this, where these are the questions that the screener asks, has to answer.
But
I'll send a link to the rules to the committee.
Yeah.
Yeah,
that would
I
be
was
It'll be
looking for,
posted on the website.
it sounded like they were in eligibility criteria for VR itself.
Oh, I see, not the screening
Right.
questions. Yeah, yeah.
Uh,
That would
but
be
I'll find
actually
it.
pretty
I can
interesting. That's a good idea.
We'll talk to Sophie too.
This
So, we have to go to the floor.